Okay, Rachel, the first thing I wanted to ask you was what you thought about Lori being sick and the jurors all having to go home yesterday.
The judge made the right call. If you have a defendant, especially somebody pro se, or as they call it in Arizona, pro per, he's got to make sure she's well. And if she's genuinely sick, that is a reason to delay a day, delay a half day, even delay the trial. I tried a capital murder case here, and we were day two of like what was going to be a 2 week trial. We'd spent 3 or 4 days picking a jury, and I got the flu. I just couldn't even think. And so the judge, I went up to the judge after the morning. He could tell I was off, and I said, "Judge, I need a half day." And everybody went home, and the jurors who were sequestered went back to their hotel. And so it happens in the court by and large with people who are credible. And while Lori may not necessarily have the highest credibility with what she says, she's been at every court appearance. She's always there. She hasn't given the court difficulty in that area. So it doesn't surprise me that the court took her at her word, wants her at the best of her game, and is giving her some time to either get well or get medicine.
Now, what would happen if a defendant continually said, I'm sick, I have a cold, and the judge knew that maybe they weren't telling the truth? They just wanted to get out of it or extend things out.
Somebody who has a pattern of conduct like that, which that stuff does happen, in most places, what will happen is the court will make a record of that pattern of attendance, give them a warning. Sometimes there's even a warning that they give by case law. It'll be written into the case law, like your attendance, your courtroom decorum, your behavior in the courtroom shapes your participation, and your failure to participate within the rules, you can go so far as to waive your right to appearance. You'll hear the judge make a record. You'll hear them talk about it. They'll give them every benefit of the doubt, but there is a point at which a judge can make that call to go without them, to make them sit there. And there are some even extreme examples where they can take other measures. So there are tools a judge has when somebody is abusing the system to ensure their appearance or to make a really solid record that they've waived their appearance. My personal belief is Lori Vallow is nowhere near that. She's done nothing but advocate, albeit not particularly well for herself. I don't think this is a situation where Lori is trying to get out of her trial. She likes the attention too much, but the judge
Okay.
has tools if he wants them.
Yeah, so I was going to ask, there could be a trial where the defendant doesn't come.
Absolutely. Absolutely. That trial in absentia, most places the court will have a process and a record they'll build, and it'll be a very public record where the judge will make a series of findings saying that the person, by either their behavior in the courtroom, their behavior out of the courtroom, or God forbid they take off mid-trial, that they've waived their appearance and they're going to go ahead. I'm getting ready to try a case where I am filing a motion for courtroom decorum, where if somebody's behavior in the courtroom is so extreme that they will essentially have either waived their right to appearance or the court can take more extreme measures. And so it is not typical, but it's not unheard of that the court will rule on some of those motions. Where I practice, in the places I practice, it's called motion for courtroom decorum, or motion to try the person in absentia or to bind and gag them. Um, those are the bind and gag is very rare, but the court has a lot of tools. But you would have heard a lot of records coming out of the judge for Lori Vallow, and he would have been very, very clear over a period of time that she was treading on thin ground. None of that's happened here for Lori.
Let's talk about some of the recent hearings with Lori Daybell. She has definitely become more vocal and more argumentative, you could say, with the judge. And many of our commenters are saying, Why can't the judge restrain her, or she's speaking inappropriately? What tools does a judge have if a defendant repeatedly interrupts, doesn't let them speak, has behavioral type issues?
Judges have a lot of tools. They're very cautious and careful in using them because that's one of the areas that's looked at really tightly by appellate courts. And you can see this judge is very conservative. He's very careful. So that he has a tool of making her sit in another room and watch by camera. He can cut her off. He can set a timer by which she's allowed, this is the amount of time you have. And when that clock is done, you're done. He can admonish her. He can tell her he's going to admonish her in front of the jury and what that impact could have on her credibility in front of the jury. That if he sees her actions as an effort to intimidate a witness, to intimidate the victim, to inappropriately sway the jury, that he can take steps to have her only be in another room and appear via television. He can order her to be in a cell and only come back periodically when she's been offered the opportunity to behave herself. I will tell you, while she is interrupting a lot, none of her behavior, while inappropriate, I don't think she's anywhere near that yet.
Mhm.
It's probably frustrating to the people who have followed Lori for years, but her behavior is analogous to what I see some attorneys who are not particularly seasoned or who are kind of chasing headlines, candidly.
Yeah.
They'll do that. They'll interrupt the judge. They'll get really combative, and that's what shows up in whatever news coverage, whatever footage there is, because that's what's unusual. So the judge has a lot of tools. He can limit her time. He can remove her and have her watch from another room. He can cut her off and warn her that he's going to admonish her in front of the jury and what impacts that can have. He can say she no longer can speak on her own behalf because her presence, she has waived that and she has a right to counsel. So the judge has lots of options. Nowhere near that, no matter how frustrating yet, I don't think. I don't even know as a prosecutor I'd ask for that. Um, I think the other thing you may see is if the prosecutor becomes concerned that this is a tactic to intimidate a witness or to sway the jury inappropriately, you'll see some motions out of the prosecutor. Were I sitting at the table right now, I wouldn't yet file that. I might raise the red flag with the judge, but I wouldn't have filed the motion yet.
Well, and it seems like the judge maybe is starting to take those baby steps. Yesterday, there were some outstanding motions that the prosecutor brought up to discuss, and he said, I'm going to issue written orders given on what happened the day before.
Yeah.
So instead of arguing it there and letting another can open up, he says, no, I'm just going to issue it. And he handed them written copies, and that was that.
Yeah. Yeah. And and Lori was given an opportunity to written responses. So you see sort of, it's almost like an incremental discipline, right? You see it transition from everybody getting to have their say to limiting your time to talk to written only. So you're seeing some baby steps on the judge controlling his courtroom.
I want to talk about the role of her advisory attorneys. And uh, are they there to, well, what is their role? What is their role? Is it up to her?
It's 100% up to her. She's lead counsel. Um, I think a good analogy would be the team you saw in Idaho, right? For Lori's case, in the end, the ultimate decider was Rob Wood. And then everybody else got a say, and you had a role, you had responsibilities, but in the end, the call went to Rob, who is very collaborative and worked really well on Lori's case with Lindsay. And they made joint decisions, but in the end, that was going to be Rob's call. So it's an analogous that Lori is taking everybody's opinion, taking everybody's advice and making a decision and moving forward. You'll see her pause and talk to counsel. Candidly, you should be seeing it a lot more, but she is in lead counsel role. So they give advice, they make suggestions. She either takes it or leaves it and moves on.
What happens if they don't like her or get tired of her? Is it one of those things that professionally you just stick with it? Or could there come to a point like her previous defense counsel, they all declared a conflict of interest and were out? And I don't know the reasoning behind that. I don't want to insinuate that they didn't like her, but there was something. So is it kind of those things you put that aside and you're just there to assist?
It is really that simple concept that you're there to assist. In the end, that's the client's case. In the end, it's the client's life. They make the ultimate decision. So, in the advisory role, they give their best opinion, whether or not they like her. In fact, if many of my colleagues are publicly candid, they often don't like their client, especially when their client has done something that is particularly heinous or awful, but they very firmly believe in the system. They very firmly believe that their job is to hold the government accountable and that their job is to protect people's rights. So it doesn't matter if you like the person, if you believe in the principle of protecting people's rights, your personal feelings about someone you put aside. And I suspect whether or not they like lawyer or not is kind of irrelevant.
Mm.
Most seasoned defense attorneys will be candid. They have had clients they personally did not like, maybe even really fundamentally disliked. Um, but their job is protect the rights, hold the government to its burden, require the government to follow the process outlined by our Constitution to take someone's freedom away. And viewed that way, your personal feelings become irrelevant. So with an assist case, it's even more so because you're not even the one having to talk.
Mhm.
All you do is give your best advice, you give it out, and if she doesn't do it, that's on her. I suspect previous counsel to go for a conflict of interest, it has nothing to do with liking the person. It means that there is something so personally broken down that you cannot even give, she will not even hear or receive your advice in a way to make an informed choice. Um, I don't believe it's this case, but I've had other cases where the defendant has actually threatened their lawyer,
Mm.
right? That's a different, you don't have to put yourself at risk. So
Could it
so
have been the fact that her previous defense counsel wanted a continuance and basically said, we don't have enough time to go through all this evidence, and she was adamant that there not be a continuance? Could that raise to the level of, we vehemently disagree here and there is a conflict?
yes, if it, and so that's the concept of you're going to be ineffective, right? If your relationship is so broken down that you cannot effectively advise or advocate, then you get off the case.
Yeah.
So I suspect it's a situation where they believe they didn't have the adequate time to even effectively give her advice. And that's, you cannot be ineffective. And that can be a personal choice or subjective standard. But for the seasoned attorneys she's had, it really rose to a level of like, look, Judge, we're going to do a bad job. And for whatever reason, us doing a bad job could affect the outcome, and we need off.
Tell me how this case is going to be different than Charles, whereas Brandon is alive. There was no murder, but there was a conspiracy to commit it. Are things different at all in the way that things will play out at trial?
Things are much different. There's going to have to be a lot more connecting of the dots for the conspiracy piece, for the underlying motivation for Lori and beyond. You don't technically have to prove motive, but motive is extremely important to helping the jury see the true story of what happened. So you're going to have to connect the dots on motive. Then you're going to have to connect the dots that she conspired or contributed to Alex's actions. So you're going to see a very different case. You know, we had some physical, Lori was physically there. The fight started with Lori with regard to Charles. So you have some physical activity by Lori directly involving Charles that's a little more attenuated in Brandon, in addition to the things you talked about. So I think the tire roll at the storage facility is particularly important.
Do you think they'll play that footage? That's what I get asked a lot because they didn't in Idaho.
Yeah, I think it depends on foundationally whether they have the right witnesses. Because you don't get to just play video, you got to have the right foundation. You got to have the witness who's willing and able to get in there and testify. And you also feel like you have to need it. Sometimes prosecutors will choose not to put things in because it opens the door. If it could deflect blame um, to the state's detriment on another co-conspirator and make them look like the primary actor, sometimes prosecutors choose not to use evidence. If the prosecution has the foundation, um, I don't think there's some of the risks for Arizona that there might have been in Idaho, where they're going to blame Chad and absolve Lori because Chad's not charged. So I think they're going to keep it really focused on Lori, and that may be something they need for Brandon's case that wasn't needed in Idaho because we didn't try her for what she did to Brandon.
Yeah, it's true. And
Right.
I guess you could argue by showing that video, well, she was there actually with
Yeah.
Chad. She
Yeah.
was there. So if it was
Yeah.
just Chad or Alex going in, you're saying that they might not want to show it because the jurors could say, well, where's Lori? She's not there.
Right. But there's absolutely in this case, she wasn't charged in Idaho for what she'd done for to Brandon. That was evidence of other crimes to support the charges we had. And injecting sort of the role that Chad and Lori both played in that video may not have been it was a choice we chose not to go down that path.
Mhm.
We were really focused on the culpability of each individual actor, and to the extent evidence could minimize their role and blame on one of the other actors, sometimes we chose not to use stuff. The defense certainly could have if they wanted to go there, but we chose to keep it really straight and clean and focused on what Lori did. And since she was not charged in Idaho directly with what Brandon did, we were given enough evidence to get that in to show part of the overall conspiracy. We didn't need to go further. The case in Arizona is different. She's on the line for what she did to Brandon. And so that video probably will have way more relevance if
So
they can lay the right foundation.
if this were your case, would you start with your first witness as Brandon?
Yes, I absolutely would. But different prosecutors try different things. I try a case where, any case, where I want the jury to see the big picture as quickly as possible. Because then when I bring in the step by step, this evidence, they have a big picture. It's kind of like when those people who do the frame of a puzzle first,
Mhm.
then you fill in the blanks.
Right.
I am a frame of the puzzle. Some people like to make sure their foundations are clear, so they'll start with the investigator and then they'll build the
So,
evidence and then they'll end with big picture. You could get that lawyers get into debates about that all the time, but
right. Well, I wonder
I,
if they did
I
start with him and then he's in the courtroom every day with his wife.
mhm.
And the jurors see him every day with his wife. And I don't know, they probably won't bring their kids, but I'm just saying, does that help the prosecutor by having this witness there in front of them daily to look at this young, handsome dad with a beautiful wife and how his life could have been lost?
Yeah, it absolutely does. It reminds the jury of who could have been taken and who was harmed. Absolutely.
Yeah.
Yeah.
Another question that so many people ask is why are they even holding this trial?
Oh.
Doesn't matter. She's going to go
Uh,
back to Idaho. What's your response when people say that to you?
the justice system has to be about more than just what sentence someone gets, right? If we want a system to reflect potential harm done to someone or actual harm done to someone, then you hold Brandon's trial. It, justice isn't about a number of years. Justice isn't necessarily about a sentence. Justice is about accountability and the person who was harmed having a say. And I applaud Maricopa for not listening to the naysayers. Um, on a case like this with somebody like Lori Vallow, like Chad Daybell, um, you have to see it as justice for people, not just a balance sheet.
Good answer. Very good, Rachel. Anything that you want to add?
No, I'll be very interested. Like I'm trying a case for a couple of days at the beginning of this week, but I'm very interested to see once I'm out how things unfold and if Lori continues to be more assertive. Um, I would be very interested to see if her sickness, extends. The judge, I understand, did say something about does she have to quarantine,
Yeah.
which makes me wonder what's going on in the jail. Is there some COVID running around? Um, and so, because if she's still sick, she may choose to have counsel step up, which will be interesting.